Welcome to another episode of the Top Attorneys of North America podcast. Today, we're excited to have attorney Bradley Sachs with us. Bradley is right here in New York with us and the founder of the law office of Bradley A. Sachs. With a career spanning 47 years, he is an experienced and highly effective litigator. Bradley, thanks so much for joining us.
Good morning, and thank you for having me. I'm
That's
enjoying
our pleasure.
looking forward to speaking with you.
Excellent. Um, Congratulations again on a career that spans nearly 5 decades since your admission in 1978. When you first stepped into a courtroom, did you ever imagine that you would still be doing this today and importantly, doing it at the top of your game?
Actually, when I first stepped into a courtroom working for New York City, my cases were mostly handling cars that hit hydrants and trucks that hit lampposts. So no, I didn't expect that 47 years later, I'd be sitting here speaking with you.
Excellent. In your bio, you say you personally handle all your clients' cases and you have a reputation for being a fierce trial attorney. What's the secret to staying fierce after all these years?
The fact that I really believe that every one of my clients has a cause of action that should be heard in court, that they're entitled to compensation, and that the system is adversarial, and therefore we need to present their cases as strongly and as clearly as we can so that the juries will give them what they're entitled to.
Yes, sir. You did allude to the fact that you began as assistant corporation counsel for the city of New York, defending the city, and then Mayor Ed Koch in complex litigation. That's a unique start. How did that experience shape your transition into plaintiff work and personal injury litigation?
Well, shortly after I started working for the city, I was assigned to a division called affirmative litigation, which was suing on behalf of the city. So pretty much my entire career, with few exceptions, has been spent representing people who have been injured or whose property has been damaged. So I basically have been a plaintiff's attorney since my first days. The only defense work I really ever did was during law school when I did a legal aid clinic. And I decided at that time that criminal law and criminal defense was not going to be my passion.
Yes, sir. You founded your firm in 1987. What was the impetus? You could have stayed in public service, likely with stability. Why take that entrepreneurial leap? And would you do it again today, knowing what you know now?
I was working as an employee for a personal injury firm. The firm was heading in a certain direction that I didn't really want to head into. And I said this was an opportunity for me to take a chance on my own. Fortunately, I had made a lot of contacts along the way, and other attorneys started offering to have me handle depositions for them, then started asking me to handle trials for them. And before you know it, I had enough casework to sustain an office on my own. Further, I
Excellent.
never wanted to have or be part of a large organization with the responsibilities that come with that. I wanted to spend more time focusing on developing my cases and having relationships with my clients.
Yes, sir. And you have received numerous accolades. You've been recognized by your peers and recognized as one of the top 100 trial lawyers. And importantly, you've been selected on the New York Metro Super Lawyers list every year since 2009. Let's dig in. What one attribute separates truly great trial lawyers from good ones?
I think the willingness to spend the time to learn your case, and most importantly, to be able to recognize what it is that will draw people in to care one way or another about the outcome of a case. You know, when most people get called for jury duty, they always, as we all do, make an expression of some curse word, which I'm not going to use right now. And in order to overcome that, you really have to appeal to a jury, a potential juror, that what they're doing is important and that why your case or my client's case will be of interest to them while they'll enjoy their experience. And for the most part, I would say that after every verdict I've had, and we've spoken with the juries, they've all agreed that it's an experience that they're happy they went through, and they really did believe that they were given a chance to make our system of justice work the way it's supposed to.
Excellent. I'm glad you answered that because that leads me right to my next question. Because you do deliver results that typically exceed clients' expectations. How do you manage clients' expectations from day one? Do you promise them the moon and then bring them back to the stars, or do you underpromise and overdeliver?
I never answer a client's question of how much my case is worth directly. I'll talk to them about how much earnings they've lost. I'll talk to them how much their medical expenses have been or their out-of-pocket expenses have been. But I'll only say to them whether I think they have a case that could sustain a substantial amount of money, and I'll define that any way that moves me at that moment. But I try not to talk about specific numbers. And fortunately, to date, I have not had a disappointed client yet.
Excellent. And you did mention juries earlier. When walking into a courtroom with your client, what goes through your head in those moments before the judge or the jury arrives? Are there any rituals, superstitions, or mental checklists that you go over?
I really don't have any specific superstitions or um, rituals that I go through. When I walk into the courtroom, I walk in confidently because I know that I've prepared my case. I know every aspect of my case. I know every deposition transcript. I know every piece of evidence. I know what's going to happen. I try never to be surprised by what takes place in the courtroom.
So you've developed a sixth sense for when a case will settle or go to trial. What cues do you look out for?
I assume that every case will go to trial and will go to verdict. And I think it's that preparation that leads to the settlement of most cases and a confidence in the courtroom that a judge and a jury will pick up on very quickly. Not that I'm being cocky or in any way conceited. I'm simply saying that the jury will see that when the promise that I've made that they'll have all the material, information, facts, and definitions of the information that they need to know, when they see that they're receiving that, they tend to be more, I guess the best way to say it, they're more open to my client's cause because we keep the promises that we make from the moment we introduce ourselves.
Yes, sir. And conversely, has there ever been a case that haunts you? I know you've had a lot of success, but has there ever been a case that haunts you because it didn't go the way that you expected? And did you, what did you take out of that? What did that teach you?
Well, I guess the best way to say is I guess you have to learn that you can't win every case. And while I try to win every case, there are times in cases during a trial when you can almost feel the air leave the room because you
Mm,
know something has happened that either was so strongly in favor of the other side of the case, or a witness was made such a major change in their position or mistake in what they said that you just know there's no way to resurrect what's happened. And at that times, it's you just have to take what's coming and know that you didn't, that at least I know that I did my best. And when the door closes, you move on to the next case.
excellent. And I know that you have represented victims of nursing home abuse, law enforcement misconduct. These are emotionally charged, high stake cases. How do you personally avoid burnout and maintain empathy while going full throttle?
I try to, in my personal life, I try to avoid having anything to do with legal matters or legal cases or thinking about law. I enjoy outdoor activities, hiking, climbing, biking, and I kind of blow off the steam that way. So when I'm in court, my focus is on one thing, and that's my client.
Yes, sir. It's important to have an out. a little bit of relaxation, turn the switch off. Uh, for young attorneys thinking about entering plaintiff side litigation in New York City or even nationally, what are the most important things you wish someone told you when you started?
Well, I was very lucky. When I left, well, I should say, starting working with the city, I had an opportunity to work with some of the best attorneys at the Corp Counsel's office, having risen very quickly through the ranks to where I was personally assigned to cases of interest to the mayor. So, number one, you get to see the work ethic and the habits of important lawyers that were working with the city. When I left the city, I also had the fortune or the good luck to work first for the firm of Julian and Schlesinger. And Al Julian, although not as well known as some of the other famous trial lawyers like Harry Lipsig, was one of the best trial lawyers New York ever had. And an opportunity to work side by side with him, and as we said, carry his bags into the courtroom and be a trial assistant. And he had a partner by the name of Leonard Finns, who was a former Supreme Court judge and also made quite a reputation as a trial lawyer upon leaving the judicial system. He also allowed me to assist him in watching these men work, learning how they approached the case. Mr. Julian approached his cases from the point of view of cross-examination, that he would handle a witness most often during the cross, whereas Mr. Finns put his entire case in by starting out with the adverse witnesses, cross-examining them, direct examining them, and putting his entire case in during the direct case. So they had different styles, both of which were effective, and I had a chance to see both in action and adopt some of what they were using in terms of how to approach the examination of a witness.
Excellent. Very important to have good mentors, especially in the beginning. If you could change one thing about how the judicial system treats personal injury or medical malpractice plaintiffs, what would it be and why?
I think in New York, at least, the one thing I would change is allow cases to get to trial quickly. When we watch these cases on television, a case begins and ends in a 1 hour segment. And while we know that's
Mhm.
realistic, the point is the focus of the whole system is on that case and helping it move its way through the procedure. Here in New York, in particular, the court systems are so crowded and so jammed that it's hard to maintain momentum for years, where you start out strong, you get all the preliminary work done, then you get put on the trial calendar. And in some counties of New York, it could be years before they call you back in to work on the case. And I think the one thing that needs to be changed is that just like criminal law, civil cases should be swiftly handled and resolutions sought early on.
Excellent. And obviously, COVID, technology, remote proceedings, they now play a huge role. How has the firm adapted your trial preparation or courtroom style in this digital era?
Interesting, while I've adopted all the different digital approaches to presenting evidence, I find that juries still most appreciate our big blow-ups, our boards, putting things that they can handle, they can touch, they can take into the jury room. They can never take videos into the jury room. They have to come back out to the courtroom and ask specifically to have something played. But when you have a flip chart or an anatomical drawing that's placed into evidence, the jury has something tangible. They take it into the room with them. They reenact the trial, they reenact witnesses, and they feel that they, I think, participate more. I think televisions are very, or monitors are a very cold medium.
Yes, sir. What drives you after 45 plus years in the game? Is it the pursuit of justice, the thrill of the trial, the gratitude of clients, or do you simply like showing up the opposition?
I I like all of those. We like the elegance of putting together a plan and watching it come to fruition and come out successful on the other end. I'm a very competitive person, and in a way, instead of being in a sport, trial law has a certainly has the opportunity to have that feeling of victory. And the other nice part is, unlike a lot of other things you can do in life, every case has a beginning and an end. And
Yes.
seeing things come to fruition makes a big difference, I think, in life.
Excellent. Looking forward, what do you want your legacy to be in the world of litigation, both for your clients and for the broader legal profession?
A few of my cases have stood the test of time in terms of the legal issues or the damages issues, and I guess that'll be the legacy that I leave. I don't work for a firm. I'm not looking to have other lawyers, continue my practice. So I think my legacy will only be in those cases that someday some other lawyer will be looking up and find it useful. And I think that's a good legacy and quite enough for me.
Yes, sir. Without breaching confidentiality, can you tell us about a case where everything seemed stacked against you, your client, but you were able to turn it around? What made the difference?
Well, I had a case involving a malpractice case involving a young man who had a congenital problem that was improperly taken care of when he was a child. And as a result of that, um, as he grew up, he became disabled on one side because of this bad hip. And I ended up trying that case in federal court, I believe in Schenectady, New York, a very conservative place, but at least it was in federal court. And the jury found against me and dismissed the action. I took it very, very hard because I thought we'd put in a good case. I thought we had destroyed the testimony of the defense expert. And I really thought that there was no defense that a jury could possibly latch onto to find in favor of the doctor. When we went up on I made a motion after that trial to the trial judge to set aside that verdict, and the judge agreed and set the verdict aside. And when I went back to retry it, a verdict was directed for the plaintiff at the conclusion of the expert testimony. So it was very personally satisfying to see victory grabbed back into place after defeat. And I think that was certainly my best or most important experience in terms of making things right. I mean, I've had a lot of other fun cases. I've represented owners of giant tortoises that were killed due to overheating. I've represented models, movie stars. I mean, I've had a great time in not so much the size of the verdicts, but sometimes my best cases are the smallest verdicts with the most satisfaction. Just the fact that the defense are get so arrogant over how they don't think they can lose and they don't think the case has value. And then you show that a jury of people listening, keeping open minds, can put that to lie.
Yes, sir. And you said it yourself. You handle a wide spectrum of cases, medical malpractice, trucking accidents. I mean, you're almost at extreme ends of the spectrum. Complexity, emotion. What, which cases give you more adrenaline and why?
I can't say that any case gives me more adrenaline. If the case is going to trial, once I set foot into the courtroom, the adrenaline flows. It's a place that, after doing this for so long, it's almost like walking into home and feeling at ease and knowing that what's going to happen, I'm prepared for. And during the course of a trial, it doesn't matter what's going on behind me. I lose all sense of everything except looking at the witness, the judge, and listening to the defense attorneys.
Yes, sir. Yes, sir. Obviously, you could write a memoir, um, Litigation in Life, the Bradley Sachs story. What would be the one anecdote you would start your book with because it says everything about you?
You know, I think I would start the anecdote, and it's indirectly about a case. I was in the middle of a trial in Rochester, New York, involving a woman who had an undiagnosed appendicitis that was uh, that burst just before she went into labor. So it was both high risk for her, high risk for the baby. Fortunately, the trial worked out with a plaintiff's verdict. But I was in the middle of cross-examining a defense expert when the judge called me to the bench and whispered something and said that I had a phone call. Now, I'd known that my wife was having amniocentesis um, because she had reached that point in her pregnancy, and she was calling to give me the result. So I was a little bit concerned in the middle of the trial that she felt it important to interrupt me to tell me something. So obviously, I was worried there was bad news. Instead, I learned that I was having twins, and I came out of that robing room after that call with the biggest smile on my face that I've ever had. And I would say to you, that's probably the best anecdote. And the defense attorney was very upset because he's convinced to this day that that's why I won the case, was that smile when I came out of the robing room.
Excellent. Excellent. I love it. For our listeners looking to contact you, what is the best way to do so? Your phone number, website? I know you always make yourself accessible to your clients. What would be the best way for someone to get a hold of you?
We have 24-hour a day live answering service. I return every phone call that I receive from the answering service. You can reach us online on the website, saxlaw.org, or at bsax@saxlaw.org. I will respond to every inquiry, every email, every phone call.
Excellent. Bradley, it's been an absolute pleasure having you on the show. Your career truly embodies dedication and the deep devotion to justice. I mean, your early days defending the city of New York to leading your own firm. I thank you for joining us today.
Thanks very much. I wish you a good day.
Thank you for listening to the Top Attorneys Podcast. The Top Attorneys celebrates the achievements of leading attorneys across the nation. To be featured, send a message or visit www.topattorneys.us.